Good morning. Welcome to all of you to this third day of sessions on the International Dialogue. Today we have the delight of having Dr. Arturo Bárcena Zubieta, who is the General Director of the Dr. Bárcena has been present in the development of the line investigation on methodologies of institutional education. He has been present since the beginning, both in the design of the courses and proportionality, as well as the seminar as attendant and a speaker. This makes our happiness greater because we are going to enjoy this presentation and comment on it. He is going to talk about on the proportionality in the jurisprudence in the Supreme Court, challenges and underutilization of the laws. Thank you, Dr. Bárcena. Good morning to all of you. Thank you very much for that. Such a nice presentation. First of all, I would like to thank the Center of Constitutional Studies of the Supreme Court. Very especially, I would like to thank Ana Maria Barra, the director. I want to congratulate you for this event, which I think that it has such a relevant and important themes, because we need to see that we are in a very important constitutional moment, and to broach all of these problems of methodology, which is quite relevant. Also, I would like to tell you that this is an honor and a privilege for me to share this conversation with experts and professors whom I have read their dissertations, and has been great knowledge to me with regard to this proportionality subject. As Diana was already announcing the title of my presentation, I think that you can infer the way I'm going to approach this subject. It is important for me to do this explicitly and to tell you which are the starting points of my presentation. What I plan to do is to do a synthesis or a summary, to say it somehow, of which has been the approach of the Supreme Court to this subject in the last 15 or 16 years. And after this, as of this rebuilding and reconstruction, we will do a reflection on the challenges that lay ahead to use the proportionality in the methodology of constitutional control. That would be my plan for this presentation. But before going into the subject, I think it would be important to clarify these starting points from which I will talk. Especially, I would like you to pay attention to the presentations have been coming before my time. I believe that the perspective that has been philosophical has been adopted, which I think is quite interesting, and that are basic and fundamental. But this will not be the way that I will approach my topic. Some time ago, Guy Muller, a professor from Germany, who recently studied the subject of proportionality, has made some valuable findings. He said that proportionality should have different approaches. He also highlighted too, there is an approach which is external, where we're discussing the philosophical foundations of the test. It is mostly critical code, and he specifies all of the problems, and he attributes to this that this is an instrument that will potentiate discretionality. And he also says that the foundation, the grounds is a rational tool, and we can qualify these as external. He also says that there are focuses on proportionality that are done from an internal perspective. And from this internal perspective, we would not seek to abolish the proportionality test with allegations that it's not rational and that it potentiates discretionality. I think proportionality is a tool that has traveled around the world and has been settled in different high courts and in some international laws and constitutions. So the possibilities of the proportionality test to disappear from the practice, so that in his opinion, and I share it too, what would be advantageous is to do an internal approach where we identify the problems and the spheres of discretionality of the test. And we should also work and reflect more with regard to the way to improve this tool. That would be the perspective that I am going to adhere to, say somehow, in my intervention. This would be in the first place. That would be a starting point. A second issue that I believe is important is that the term or the concept of proportionality is not new in the Mexican constitutional doctrine. When I say that it's not new, it means that it doesn't go back more than 15 years. It's something that in the court precedents is much new, but proportionality is going to be broached not in the way it's used in the proportionality framework. Proportionality has been there since a long time ago, such as what is set forth in the Constitution, Article 42, that penalty should be proportional to the crimes. There is a concept of proportionality that is not something that interests me for the purposes of this presentation. It is mostly known of everybody that is the tributary proportionality that is set forth in the Article 31 that sets forth that Mexicans should contribute to public expense and of proportionality. There's a concept of proportionality that has existed for more than 15 years. There is very intense debate on the significance or its explanation, but for the purposes of this presentation, it does not interest me. The third issue that I think would be important to plan is what is the weight type that I'm going to refer to in the framework of this presentation. Proportionality is a type of weighing, but I'm not going to focus on what could be rated as Giorgio Pino said as direct weightings that suppose a direct conflict between two fundamental laws. One is fundamental or a constitutional principle. Those conflicts happen without the intermediation of the law. This is a specific case of a conflict, are the conflicts between freedom of speech and freedom of personality. In the large majority of the federal entity is that governed by a specific law. These conflicts happen in a direct manner without the intermediation of the law. These weightings are going to be set aside. I want to talk about the indirect weightings, which weightings are mediated by the law. The law picks up a conflict between two laws, and the law picks it up and resolves it to say it somehow. And the exercise of weighting is goes to see if this is done correctly. And this is within the framework of the law, constitutional law. I'd say that this type of weighting sometimes can be called meta weightings, because the constitutional president analyzes if the weightings done by the legislator is correct, to put it some way. That type of weightings are the things that interest me, and I repeat, those are the ones that are happening within the constitutional framework of the law. This would be my third point of start. And one fourth starting point that goes together with the previous point is that I am interested in the proportionality test as a methodology of the constitutional control of the law. But it's just not any constitutional control of law. It has to do with the violation of the law, because methodology of constitutional control can vary depending on the allegation of unconstitutionality, which has been explored quite a lot. It is in a didactic way we can distinguish three types of arguments of inconstitutionality. Some are formal arguments that have to do with the legislative process, or when because it doesn't follow the legislative process, and they follow the others that follow other methodology, and there are other arguments that are formal. For example, when you have a determined legislation power, either federal or state, that type of elements are solved with certain methodology. I am interested in the arguments where it is alleged that the legislator has violated a fundamental or human right. And that type of arguments should be responded in a certain way. In the last years, we have used the test of proportionality to use this type of concept of violation of rights. But I also do not disregard that in that methodology of proportionality, there are others and there's one that is called the traditional methodology of control in the laws, which is interpretative law. It's like construence of the law, construence of the constitutions, and see if some meanings of one or another are compatible, to the effect that if what we establish and the law provides is contrary to what the Constitution says, then that methodology will indicate that the law should be declared unconstitutional. That would be the traditional methodology, which I would say is still the most used methodology. But in the latest years, I repeat, this has been settled in the Mexican culture and also in the doctrine of the Supreme Court. And it's an alternative methodology, which is a proportionality test, which we have been talking about in the last days. And supposedly it contains different elements and characteristics that differ from that traditional methodology, which would need a different analysis. And one last clarification in my intervention, which is mostly a side note, to the effect that even though I'm going to focus on the idea of the proportionality test and a methodology of constitutional control, we shouldn't lose sight of that the proportionality test is a tool that is urgent for the control of constitutionality. And this comes from Germany, that starts from the bond law of 1949 that starts using this methodology for the control of the laws. But this methodology had been used in the administrative law. So even in the Mexican culture, the proportionality test has already had the reception in different areas of constitutional control, and the methodology that is applied to these different areas of constitutional control has significant differences as to the way that this is developed in the area of the constitutional control of the law. We should bear in mind that the proportionality test is a tool, as seen as in general term, helps us to control several discretional powers of some authorities. This explains, for example, in the case of the Mexican law, it has been received as we have received the proportionality test to be used for certain decisions. The criminal judges have to make certain determinations using the proportionality test, because this test is a tool that will help us control the means that will be used to get to certain ends. In criminal law, the precautionary measures and biological issues are used, but not only has it been used in the criminal process, and it's not only has been received in the criminal law. For example, in issues such as transparency, law of transparency sets forth that the proportionality test has to be used when two types of decisions are used. On the one hand is what is called the test of public interest. According to the test of transparency, the public test has to be done using the tool of the proportionality test and also the damage. And those are the 2 points that are important to be highlighted. And that this tool is only for the constitutional control of the laws. It can be used in different areas, and even in the laws that are ordering in certain subjects or certain areas this test is used to justify certain decisions. But to talk about this will take too much time. So I am only going to focus on the proportionality test as a methodology of constitutional control. And finally, I would like to point out that using the proportionality test as a methodology of constitutional control, it's not a matter that will be explained as a methodological matter, as I believe it is. And that is the way I'm going to explain it. I believe that this trend in many courts at the worldwide level and international human rights courts, using this tool not only has to do with the methodological decision, and I think those are one of the precedents that underlie my presentation. I believe that using this methodology needs some compromise to the constitution of the rights, which is sometimes incompatible with what I believe, at least in our country, it is an understanding that mostly accepted. I think that the more classic doctrine on human rights or on the fundamental rights. And it is this idea is that the fundamental rights, to say it using the terminology of Gorky, are the victory letters that finally can be pursued by the political majorities. To this effect, these are strong conceptions of the fundamental rights. And I believe that this is still the majority conception. despite of what I'm going to explain further on. So to use the test of proportionality means displacing the idea of Gorky, or this idea of the rights that are established in the area of non-decidable. And I think that those things of the law can be incompatible with the idea of rights that is underlying the sub-utilization of the proportionality test. Of course, I'm referring to the idea of Robert Alexi, to the fact that the fundamental rights are optimization mandates. It seems that behind this methodology, there's a conception of rights. And there is a fundamental problem which I see is not being used sufficiently. In my opinion, the methodological option is given by a certain conception of the fundamental rights that have to be embraced in order to use that methodology. So this is a bit the background that will have to do with what I'm going to talk about. Now, from my point of view, I will tell you how the Supreme Court has approached the proportionality test during the last 15, 16, or 17 years. And in my opinion, this is a period where this tool has been used by the Supreme Court as a constitutional control methodology. Having said that, I propose that we make an admission of two epochs or two developments throughout time of this test. The first epoch, or the first period of time that we could trace back to 2004, where we have the first judgments where the court refers to the proportionality test, all the way to 2010. These 6 years could be featured as the years of the exploration of this methodology. And these were the years of exploration. And right now we will see how this approach has been carried out, because it hadn't been used before in the constitutional doctrine of the court as a tool for constitutional control. So that way they started to support that methodology, and they started to try to make the first trials to see how they can apply these methodologies internally. So from 2004 to 2010 were the years of the exploration of this methodology. Normally, these are specified as the first judgments or significant judgments where the methodology of the proportionality test in the direct writ of amparo from 2018 to that was dictated in 2054, and in 2004 that was judged in August in 2005. Generally, there are few studies about proportionality in Mexico. There are very few authors that have broached this subject, and they identify these two judgments as the pioneers where this methodology was used. I have identified one that was prior to that, which is direct writ of amparo in 2006. And from here, I would like to approach some of the things that the court said to see how the court phrased this when they started to introduce this tool for the first time. I repeat, in my research, this is the one that identify as a first judgment that used this test. I'm not saying it's the first judgment that had used the first test, but if you analyze the judgment from my point of view, the use of the proportionality test in 2003 was novite, because the reason the analysis of constitutionality in the end does not focus on the proportionality of the measure, despite that this has been announced in the judgment. And I think this was the first time the Supreme Court made reference to this concept. In the concrete case, this was a case that was analyzed the constitutionality of a procedural norm that extended the term of the parties to submit the writings before the courts. And because of the problem that was being analyzed, it is interesting to see the phrases used by the court to introduce the test of proportionality in that judgment. The Supreme Court said that they noticed that the effective right application can be vulnerated if they impose requirements that hinder the decision of the jurisdiction. If those hindrances are unnecessary and ineffective and lack the Supreme Court says gave the elements to understand that what it was proposing that they should carry out an analysis of proportionality of a norm that limits jurisdiction, access to jurisdiction. And to do that, they said they had to take into account the objectives that were being pursued with those limited measures that will be give right to access of jurisdictions. We would see if these decisions were unnecessary, or all of these expressions were used as synonymous of the measures that lack reasonability and proportionality when in subsequent they had. But the fourth one, I believe, that is clear that it announced that this would be the methodology that they would be using. Even so, the judgment clarified in a very conclusive way that not all of the requirements for the access to the process can be rated as proportional. They could appeal to the jurisdiction validly because it was a right that can be limited. It cannot be rated as these fundamental rights are there to preserve other interests that are protected, and it keeps the proportionality with the pursued measures. As you know, the proportionality test supposes a conflict where there's a legislative measure that is affecting a right, but that affection had to be broached, because with that measure, you can also advance to other constitutional ends and other rights and other principles. This is a conflict that underlies the law that is being analyzed, and for this, proportionality will be useful to us. I think it is interesting to see that the elements are there of proportionality in this first approach of the court. But of course, these elements will continue to be tweaked throughout the years, but they were there at that time. It did not develop, and the Supreme Court of Mexico did not develop or establish, give an explanation, and they did not run the test appropriately. In these lines, I believe that they describe it in a clear way, that what they attempted to do was to use this methodology. So I think this is the first judgment where the court uses proportionality. In these first years, I repeat, I identified it as the years of the exploration of the methodology that go from 2004 to 2010, are featured by several notes. In the first place, there are not that many cases. It only reviews the judgments of that period of time of the court. where the court used that proportionalities, and I believe they're not more than the 30 judgments, and so they're not that many cases, especially if we compare 30 judgments against the volume of cases that the court resolved on during that period. There are very few judgments using the methodology, and what other characteristics would this first epoch would have? I believe that to a certain point, there's conceptual confusion in the explanation of the degrees of the test. As you already know, in the latest years, it is even more clear which are the grades of proportionality. And we could say that there are basically four: the identification of the constitutional finality of the measure, the appropriateness, the needs, and the proportionality in certain sense. I think those grades allude to certain concepts that have more or less precise concept. There are some cues to this, but they have a more precise definition. In these years, we see a lot of confusion in the court's judgment with regard to the proportionality test. Sometimes they say appropriateness, it gives a sense of need, and also the proportionality would be the meaning of need. And we can see this in we can see this inconsistency happens during these first times. I think this is normal because we were importing this tool, this methodology, so that I believe that this isn't too scandalous, to put it some way. Another characteristic note is that during those first years, there were several judgments of the Supreme Court where it seemed that there was special interest in showing that the proportionality test and its use resulted directly from the Constitution. Like if using the proportionality test was ordered by the Constitution or by an article of the Constitution, they only made reference to Article 12 and 16 of the Constitution. And this generates the obligation of the use of this tool. Of course, this can also have an explanation to that effect. Since it was a novel tool, they wanted to give it strength to its application in a way that it wouldn't be questioned, but this is a characteristic note of those first years. One third note, I would say, is the fact that the large majority of those cases where the court used proportionality during those first year, well, it analyzed was a specific type of constitutional problems where there were different legislative distinctions to see if they were contrary to inequality. They were constitutional decisions that violated the rights and the rights to equality in those years. That was when in those years also inequality was starting to be developed. And in my opinion, the most distinctive note of these first approaches of the court to the proportionality test is what we can identify as a methodologist syncretism in the application of this test. And a professor like Luisa Conesa has alluded to it in a more colloquial way. We could say the tropicalization of the proportionality test is this is a methodological syncretism. In many years, this is a product of the analyzed products that were analyzed that had to do with equality. So the years that they were using the proportionality test as a German matrix, the strict scrutiny that came from the American tradition, although it's similar to the proportionality test, culturally, it comes from different areas and it has significant differences. In these first years, I repeat, were marked by these methodological syncretism in the judgments of the court. With this, I would end those first years. After this, from the years that are what I call the consolidation years of the methodology that go from 2011 to date. This is a longer period of time, and this period of time had a more intense use of the proportionality test. What does this consolidation and this more intense use of the test of proportionality explain in the constitutional control of the laws? I think that there are several factors that undoubtedly that contributed to a more intense use of this test. In first place, we should say that constitutional reforms on human rights and the writ of amparo of 2012. In fact, this year we celebrate 10 years of those reforms. Those reforms were very significant for this cultural change because these reforms had an interest in the court. So the court was interested in including these tools of education that were not present in the Mexican culture to solve human rights problems. Of course, these tools that were incipient in the doctrine and that were being used more intensely were using the proportionality test. Therefore, there is an effort of the Supreme Court of these years to see how other higher courts in the world or human rights international courts were resolving the problems related to this. And in that effort of including other methodological tools, I believe that this tool was used more intensively. I believe that it also aided the more intense use was the judgment of contradiction of 2011 to 2013 because of the constitutional hierarchy of all human rights that were of international human rights that also included other concepts of human right violations, but it also gave entry to Mexican court precedents that had incipient use, and in the test of proportionality was being used in different modalities. I think that there is an important issue that we need to highlight. And although it is true that during these consolidation years from 2011 to date, most of the cases are cases that analyze constitutionality of legislative distinctions. I think those are the cases that the law studied the most. And right now, during this period of time, we had a large amount of rights which violation was analyzed using the proportionality instrument. I will list only some so that you can understand what I'm referring about, category of personal freedom, the right to justice, freedom, the right to be voted, the private free development of personality, the right to employment and stability, the right to effective judgment, the right of reply, the right to have a test, and to have an adequate law, and the the right to develop personal traits, and those were analyzed during this period in different decisions of the court, and they used this methodology of the proportionalities. This also caused an experience in using the test, and it caused the growth of its use, because when they used this, the decisions were more valid than in the first epoch. So, which could be the balance of this more intense use of this tool in the last years, in addition to the reflections going forward, which I will approach later on. I believe that the balance of its use, I believe that the Supreme Court has achieved better comprehension of the proportionality test. And we can no longer see, in most cases, there is a conception used with respect to the different degrees of the test. I think the use is more coherent with regard to the categories that were being used. And in general terms, I believe that the quality of the deployment of allegations have improved substantially. And now that I believe that we had a big progress in the use of the test, I cannot say that there haven't been any problems in using the test in the doctrine of the Supreme Court. And I would like to devote the last minutes to this. I would like to attempt, without it being a systematic exercise, I would like to give some ideas which I believe that can profile an agenda of what will follow in this proportionality test in the frame of the constitutional doctrine of the Supreme Court. Obviously, I do not view that the tool will be stopped, they will stop using the tool. I think its use will continue, and I believe that we need to tweak some things and we need to pay attention to some items. Firstly, I believe that the fact that we are discussing this at the international level in the context of an activity of the Study Center of the Supreme Court is something very important, because it talks of the interest in different areas, that there's a cultural dissemination in the court to cover and to give more understanding of the test. And I believe it is very important to discuss the methodological aspects of it. I have even heard it among the judges and justices that their ideas that the methodological issues are not important. The judges can even arrive at decisions through different ways, but the form they arrive at the decision is not important. The idea is the arrival point. When we discuss this, I think, and I want to share this, yes, it is important to know how we arrive at those decisions, because we need to know which is the path we're going to follow to arrive at decision, because that contributes to certainty and legal certainties and the belief in the courts that all know how the study of an allegation is carried out. We need to continue to work on the discussion on the methodology, and I think it's crucial. If one analyzes the judgments of the Supreme Court in recent years, we still find some, although that we know there's a clearer understanding of this tool, I think that the judgments and the classification is a poor. And I don't want to criticize anybody where they have two paragraphs where they explain the proportionality test. I think that it is important that they use all of their potential so that we can arrive at a better justification of certain decisions that are being made. I believe that an analyst of the cases where the court is using the proportionality test, I don't think they're routinary. They're cases that for some reasons they're complicated, and the proportionality test can contribute a lot to have a more robust explanation. But in order to not avoid trivializing the test in the writs of amparo, I believe that it is important that we consolidate a methodology approach where we are consistent in the way we deploy this test, and that we do it with enough details so that the decisions can be justified and explained in a better manner. In this context, I believe that the judicial reform that was passed recently attempted to consolidate the Supreme Court, also made the court to make more precise decisions and to have a better jurisprudential developments and more methodological developments. And I think there will be more cases where the Supreme Court will work on, because the load of work that they have currently make it difficult to deploy this type of allegations with all the details that are required. I believe that judicial reform aims at consolidating and allowing the test of proportionality to explain the decisions of the Supreme Court in a better way. Another issue which I believe is important, and it's mostly a reflection that we need to make in the academy. I think that too much attention has been made on the proportionality test and its weighting, and other grades of the test have not been studying, which I think is very important. And I believe that they don't have the same objections as if they use the weightings. I think things are being decided at any rate. I think that proportionality is aimed at the last step. I don't think these apply to the other grades of the test. They are also very powerful to justify the decisions in a better way. They also have elements that are quite novel in the jurisdictional area. The first grade explains which is the constitutionality of a measure. And I think this is very important because the measure that is being contested, and it could be analyzed under a better light with regard to the constitutional finality being pursued. And to say it in Gorkinian methodology, it would be the best version. Because if we disconnect it to the constitutional measure that it pursues, its defense, the defense of the constitutional measure is much weaker. And the next stage, which is appropriateness, which is novel, because if we think of it seriously, it has factic and probationary allegations, and this is something that normally was not considered as necessary, that is the probational issues wasn't something that has been analyzed, at least in the Mexican doctrine that tends to the constitutional application of laws. I think this is something that requires more attention. And what I think that is the most powerful tool within the proportionality test to analyze the constitutionality. If you analyze the tactics of the court itself, most of the laws that have been declared unconstitutional by using proportionality have not helped to overcome the stage of need and necessity. We have yet a lot to do on how to do the examination of the necessity of the measure. The necessity requires comparative analysis. We need to compare the contested measure with alternative measures and to make comparison in two dimensions. The measure of sufficiency or the measure of affectation of the law. I think that when you carry out this comparison, there's another novel which has to do with the constitutional control of the laws. And there are many things that can be discussed on how to do this comparison. If alternative measures have to exist, they can be imaginary, or if they can have any type of a measure, for example, the economic cost of the measure. There are many things that need to be weighted, which are not being appropriately discussed. And of course, in connection with this that I said before, that we need to pay more attention to other grades of the tests and not only to the proportionality. I think that we need to reflect on the problems that entail the application of the proportionality test. I believe that the most relevant cases where the court has using proportionality is in the writ of amparo against the legis, but it has also been used in direct writs of amparo and in and actions of unconstitutionality and abstract mechanisms. I think that these things are not exactly the same. The amparo against laws requires the use of the test of proportionality because the court needs to decide on that. And in that comparison, we can establish the defense by using the proportionality tools. And this does not happen in the direct writ of amparo and its revision. I think these are interesting points we need to reflect on. In the framework of the writ of amparo, there's also some argumentative techniques who can allege the proportionality of the measure and show that this proportionality, it could be the authority. We know that the traditional position in the amparo, they have to show the unconstitutionality, but I think there are cases where the difficultness of its use, I think it's authority that needs to defend the constitutionality of the measure using the tools of the proportionality test. And finally, I would end with 2 points which I think that are very important to highlight vis-a-vis the future. I think there's a pending issue. There's some judgments of the second room where they're analyzing this subject, and perhaps it would be interesting to tweak it or continue to go profoundly into this subject. I think it is important to clarify when we need to use the proportionality test. It continues to coexist with other methodologies, specifically with one which is a traditional one when you have allegations of human rights violations. I don't believe it is clear when they should use one or another. I have some intuitions of what could guide their use, but I think this is a subject that we need to clarify. I don't find it satisfactory that this is a methodology that can be used by anyone to respond to a allegation. I think that depending on the allegation, that then we would know what methodology to use. I think the court should continue to work this way to have a better quality of a better knowledge of what to use this methodology, so that in the framework of a written amparo, the complainants can use their allegations of unconstitutionality or defend the acts that have that have the code of proportionality. It is important that we know it at first. I think that there is an interesting topic. And finally, I believe that there's a topic that has been the subject of some of the conversations of this event and the rest of the is the use of the proportionality test for the violation of social rights. I think this is a subject that requires a different treatment, a differentiated treatment, and the methodology that was developed by the court should be adjusted to cover the subjects of social rights. I believe that those subjects that allege the regression in the social rights regression, I think this methodology can be applied quite well. But if you want to apply it to other types of problems related to social problems, I think that we are requiring the adjustment of this methodology. And I think we have found very interesting things that have been written in the academia. I think about the works of Professor Laura Kelko and also Professor Escapao. I believe that this is the subject that we are now starting to discuss. How do we deal with this tool as a methodology of adjudication? And I believe that there we have a long way to go. With this, I will finish my intervention. I want to underscore that the evaluation that we can do in the utilization of the tool by the Supreme Court is positive, and the progress that has been made in the last 17 years has been very clear. I believe that the court is making efforts both in jurisdictional and in the institution areas. It has done serious progress so that we can, because this issue not only affects the courts, we also need that the attorneys to start introducing this type of allegations appropriately. And of course, this has to go through a collective effort. And I will leave my intervention up to here, and I am attentive to any comment or any question you may have. Thank you very much for your presentation. It was so complete, and there's so many things that you approached. I think that, but many things were already approached in your presentation. So I'm going to group all of the questions by category so that you can respond to them as you deem convenient. The first category could be called as a source of obligation of the use of this tool. There are many people who ask about the source. At what point or what was the justification of the court to start using this tool during those first judgments that you referred to, and after that? And in subsequent phases, and another group of questions of that type has to do with what would happen if this was the test of proportionality were concentrated as in the Constitution as a tool to take decisions where fundamental rights are involved. These people are concerned not only with the judicial use, and they wonder if this can become the tool to make decisions in other areas, like in conciliations, and that type of spheres. And another group, third group has concerns of this, given that there are some laws that envision this test as a methodology to make decisions in these areas, which would the effect of if a court or a person who make decision under this law by using the methodology. They don't use the test, they use other tests of interpretation or semantics. If we can think that those decisions of these tools violate fundamental laws because they do not know the law or the Constitution, and to know if this statute decision is good or wrong. And that's part of the great number of groups. To begin with the first part, with regard to the grounds. I said that at that time, the Supreme Court understood that there had to be a ground on a constitutional article. There are several judgments that required the Article 14 and 16 of the Constitution. Proportionality was some sort of tool that contributed to not making arbitrarian decisions. In general terms, those articles set this forth, and this could result from there. They talked about the principles of proportionality. It seemed that was strong, like proportionality was the principle or constitutional norm. I believe that my explanation has to do that it has to say that it's a new tool that would be presented as something that resulted from certain body of laws. I don't think so. They never thought that proportionality was a methodology. And I believe this is unnecessary to have a methodological discussion. I think with the concerns that courts, I don't think this was grounded on a constitutional article. I think the court was convinced of that because in the most recent judgments in the second epoch of the consolidation of the tool, we no longer see that wanting to result to derive it from an article. And I think that there were some judgments from the last year. They say that this tool is a methodology, and they established a step. And it's a methodology as like other methodologies. I think there has been an evolution, but I do not satanize those things that happened in the first epoch, because I believe somehow this contributed that it's now that its reception generated less noise, but in other epochs in the integrations of the court weren't so prone to incorporate those tools that came from other parts of the world. I think that this incorporation was softened and they thought that was necessary. It's a methodology that is not resulting from the Constitution. It's just as any methodology, and it's at the discretion of others to apply it. If it's codified or not, that's an interesting question. Other interpretive construing techniques of the civil codes of other centuries, one tries to codify the interpretative techniques, and they established that the interpretation were such and such. I think that we do not require to, this does not need to be in the codes or in the laws. It's something that has to do in this methodological sphere, because interpretative developments certainly come from the academia. Why should we establish a code or a catalog of techniques and methodologies of the laws? with a certain level of detail, specifically. I believe that this would make the development of the methodology less flexible. I believe that it would not be in our best interest to regulate it to a certain level of detail, but it would be scandalous for it to be referred to in the Constitution with a series of allegations where there's some decision that is proportionate to law. I think that we have to study it, but only for those arguments, not for any other things. With regard to the reception that has been carried out in the Mexican laws, we have the Penal Procedures Code or the Law of Transparency or the federal laws. I suppose that it also in the local laws. If it's not there, then it's in the general law. So it would be very important. I believe that it's a problem. I think it's a problem to get to a certain detail when we have a national code of penal procedures. And this is explained, the test of proportionality is explained in a very detailed one, and it's mostly for the constitutional control of the laws. And there are elements that are different in the framework of a precautionary measure. We have to think of necessity grade, and what we have to analyze there, if there's an alternative measure that is being analyzed, which is appropriate but less restrictive, that would have to be analyzed. But in the precautionary measures, it's not that we don't know which are the alternative measures. The catalog of measures of the national code are in the national code. So the options are not undetermined, as in the case of the constitutionality of the law. The code tells us about the alternatives already, and that gives us that there's some adjustments to the methodology in the grade of necessity into the grade of appropriateness. I think it's a problem that it would be a problem to regulate it to such a detail, because we have to give space so that this methodology can adjust to the decision being made. A precautionary measure is not the same as the take of biological tests. What is true is that they're there in several Mexican laws with a certain degree of detail on how the test needs to be run. And I think that it has also been applied in the methodology of constitutional control. Thank you very much. Now let's talk about the second group of category of questions. There is a question that constantly pops up, not only in this conversation, but also in other courses. And today is not the exception. I think you've already talked about this, but it is interesting that it pops up again. And this is the addition of the second room with regard to the proportionality test. It's a methodology among other methodologies. But the question that is being made today, if there's something similar, if in the first room and the second room use different methodologies used for the control of constitutional laws, that could generate a contradiction of precedents. There are methodologies that comply with substantive measures. And let me tell you about other questions that are linked, but the subject's a bit difficult. There are several questions with regard to the potential characters that are not proportionate in certain constitutional norms. There's no control of inconstitutionality, only on constitutional norms. But the question the people start asking regarding preventive prison and it's more academic or more speculative. And that way you can analyze these tools in the light of jurisprudence and the decisions of the court on disproportionate measures. The questions are very difficult. With regard to the decisions of the second room, I believe that is a very interesting decision for what they said before. Clearly, they said that this is a methodology and this is a methodology like others. My vision is a bit different, to the effect that I don't think that you can use any methodology with any allegation. For example, the claimant or the current proposed its aggravation of its violation of a grievance of violation. There'd be a reason for not responding to say that his allegation is not operable. But if we go in depth, I believe that we need to respond to what he is saying. I don't think it would be satisfactory to answer that I'm not going to study it with that methodology that you're using. I'm going to use the other methodology. I think that we need to have a response that is based on some logic or some principle. You can say, I cannot answer that because for this reason, because this methodology does not suppose you're talking about a disproportionate limitation of a right, because a right that you are alleging is an absolute right that does not allow for any limitation. But I think it is important that right now you have broached the subject, and I think that what is interesting is its discussion. For me, it's not that it doesn't have a practical consequence. That decision, that judgment does have significant consequences, and I think it deserves to be discussed and analyzed. If there could be a contradiction of precedents with regard to methodological subjects, I think it's something that we need to think about with more carefully. But on the top of my head right now, I could say no. I would say no, because the aspect where the contradiction is hindered has to do with the point of law. And methodologically, which I think is very important, does not have to do with rights. I think we could see it in a broader sense. We consider that what I'm saying, it is important that we rate when we analyze with one methodology or with another, and that methodologies are part of the constitutional doctrine. There, I'm looking at two ways of looking at the problem. One is more strict, is not a point of right, it cannot be object to contradiction, and one that is more comprehensive, where ideological concepts are also part of the constitutional doctrine, and therefore we can approach it. But I think that the second option presents the problem that we need to see if the methodologies are, if there's a contradiction between both criteria, and it's not clear for me how methodology could be part of some dissident allegation. I think that if it has to do with a grievance allegation, I think I would have to think about it more carefully. But what comes to my mind is this that I'm saying. I don't know if I missed something else that you asked me. Yes. This question that has to do about the disproportionate nature of a figure in the Constitution. Oh, that is another interesting question. There are academics that could say that hold that this could be done. It could be disproportionately or proportionately in some constitutional doctrines. But for the American culture, there would be no issue in having a control of conventionality in our constitution in the light of the convention. For the Inter-American Court, it would not be any problem. I think that we would need to explain many things in order to show that this can be done. And I believe that what I have read from academicians that support this, that there we can find satisfactory answers. There's a constitutional control of the constitutional norms. It's not something that has not happened in other parts of the world. I think that we would have to work on it with greater detail to show different parts in order to arrive at a disproportionality test in the Constitution. But this is something that I hadn't thought about. This is an answer that I'm just getting from the top of my mind. Thank you very much. There are very complex issues and we need to continue to think about. We need to study the answer. It's not as clear. A third group of questions are focused on tropicalizations of the test. They want you to expound on the fact if you agree with the localization of the tool, because the use of localization is somehow despectively, it's not well done. It's like forcing a figure that is well constructed in less tropical lands. Did you talk about, now that you talked about syncretism and see this import? And they also ask you to expound on concrete examples of syncretism in methodological areas. With regard to the test of proportionality or the test of equality, when have they been used and how they have worked? If this is, and this is what people adjudicate to certain characteristics that you've been talking about. And other questions that come from contexts that are not Mexican. They ask you to please be more specific about how courts approach other adjudication tools or other methodologies of constitutional construence. How has this worked? That would be the third one. Regard to tropicalization and syncretism. I'm not sure the term of tropicalization term is not used despectively. According to this, my reading, I think it's mostly descriptive of a phenomenon that had already been approached in several jurisdictions, the Colombian Constitution and the Mexican Constitution. I don't have an unfavorable opinion with regard to this doing type of combinations of different methodologies. My concern has to do with the explanation of those methodologies. what I can see from this first epoch of the Supreme Court is that the syncretism translated in the lack of conceptual clarity to explain what they were doing, and that could be done properly and those things could be combined. I think so. Now that they cited an example in the North American tradition, they have scrutiny by levels where they have different types of demands with regard to the constitutional review or the alleged law or the violated law. There are several detonants where the scrutiny can get darker. It could be ordinary or intermediary and strict scrutiny, and they know how to apply it. Before they said this topic will be scrutinized with a normal scrutiny, and this will be discussed with the intermediate scrutiny. And I think that this method is a North American methodology. Of course, it is not perfect. It also has some conceptual issues and in the explanations that they do in each grade, but this is consolidated in the constitutional doctrine and its application in the courts when they carry out the analysis of constitutionality. The idea of hardening the criteria and the demand, and therefore become more stringent or more different, or to some reasons, I believe is a very interesting idea that could be compatible with the development of the test of proportionality of the German matrix. And for what I know, they don't usually use it in a generalized way. They don't combine these two issues, the idea of the grades with a hardening in each of them or in one of them would certainly have reason. I believe that this is a topic that my objection to this, I think, is that they have not been clear to understand when you detonate more strict scrutinies, when you're going to be more demanding and in what cases. And it's perfectly possible to harden the scrutiny with regard to the end that is being pursued by the measure, to harden the scrutiny with regard to duality, harden the scrutiny with regard to necessity. I have doubts on proportionality to that effect, but in the three first ones, I think it become hard, and there could be reasons of juridical policies that are interesting with which we can play with and come up with a hybrid methodology. My point is to say, okay, let's do this, let's do it properly, and explain this properly, and I think it will be clearer. More, and I think the United States does it. They're clear where they are going to decide on different grades of scrutiny. And I think that they have it clear. In the Mexican case, there are some justices that have tried to move ahead with these ideas of establishing levels of scrutiny, and in the disproportionality case, I think that would be a case of syncretism, but I believe that we are lacking some steps of clarification and conceptual clarification, and to clarify what detonates the more hardening of a scrutiny. I think that all of the questions have been covered. We are now arriving at the end, so let's have a miscellaneous round. I'm just going to have a couple of questions that are different, just to take advantage of your presence. There's a question that is more of theoretic type. This person says, you said something about the rights of victory letters that don't have nothing to do with the methodology of the test. And he is proposing an issue that has recurrently come up in the conversations regarding if the proportionality test is neutral in the theory of rights. In regards to the idea of the rights that are behind this tool. And if a victory charter is inadmissible, how can you defend its neutrality? Or should we think further on a philosophical, ethical, political, a more robust idea on rights that are behind this test? And in that degree, not all methodology will work well. We have such a comprehensive catalog, and this catalog can be reduced when we understand the rights or optimization that would allow us to weight constitutionally clear, like public constitution, guidelines, rights, or laws. And that's another questions. And the others, what they're asking you to go in deeper of the impact of the human rights reforms in recurrence in the forms of the test, and what you think would be the potential impacts of the most recent judicial reform in methodological subjects in the cases of the resolution of constitutional conflicts that you mentioned this morning. With regard to the first subject on neutrality, I believe that there is an issue that has not been adverted in the, I think in the Spanish doctrine, they have not stopped, they have lost sight of this subject. I don't think it's neutral. It's the proportionality is not neutral with regard to the conception of rights. I think that it can be used independent from any conception. It is interesting to see how we have slided towards this, the use of this methodology. We're all talking about it and it's important, but deep inside, there's a sliding towards another conception of rights. And I believe that it has significant practical consequences. The idea of conception of the rights is compatible with proportionality is quite clear. And it's interesting also to see that the things that the court has been repeating throughout the years, and it seemed to be pointing toward that direction. The courts, as the court says, that there are mandates of optimization, and there's also a dictum that the rights are not absolute. The rights can be limited. The idea that is behind, okay, it can be limited. Now let's see if the limitations are proportionate. This is now the axis of the discussion. It's not that you're affecting my rights, and therefore the norms. It's not the limit. The limitation is not proportionate. It's subtle, but I believe there's a transformation that is very significant with regard to the conception of rights, and not with what we were taught when I was studying. I think that idea of rights was letters of victory and spaces that were not decidable due to some policies. But it is interesting, like some authors like Borki and Aioli, they don't seem to be receptive in their works of this proportionality idea. And I don't think this is causal. This is with regard to the idea of neutrality. I repeat, I don't believe that the test is neutral. I believe that my problem, or not my problem, but my doubts are that perhaps there should be just one conception of rights. In my intuition, I would love to have time to read more about this and give you a more backed opinion. I think not all rights work in the same way. So we cannot have one conception of rights that will give account on how all of the rights work. I think there are rights that are very trenched in, that go more to the model that go to the idea of Gorky, and they're absolute rights there, which are not much. But on the other hand, we have the majority of the rights where that work as mandates of optimization and all liberties. And I think that there are state interests or other laws that limit the liberties. And in the middle, we have some questions with regard to the laws of the penal subject matter of, can they be limited or not? When we see in compared law, there are jurisdictions that treat it as rights that are trenched, and this doesn't have to do with the proportionality, and there are others that do accept it and they run a test. My intuition is somewhere along that line, but I don't have too many elements in order to give you an answer that is more profound. We think there's no law theory that where all of the laws work. I'm not talking out of my head. This is a judicial reasoning. It would be very rare if somebody come up with a proportionality test with respect to a norm of being affecting the physical integrity of the person. I think that's counterintuitive if a court did something like that. And with respect to the other questions that have to do with the impact of the reform of the human rights and the judicial reforms, I think that the human rights reform, it's not that it hasn't consecrated the proportionality in Article 1st. I think that it would be very interesting to have a sociological analysis of this. And I think that would be for the juridical operators, especially in the federal judicature. It was in the federal judicature, there was a detonant. And the Supreme Court and other courts were receptive to explore how they were solving the human rights issues were being approached in other jurisdictions. Why do we talk about proportionality test in Mexico, New Zealand, and Israel? Well, because there has been an approach of this constitution. I think that the problems are similar in other places, but we weren't actually isolated from the world. And we hadn't had that participation in this conversation, and there had been no interest to what was happening in other jurisdictions. And I think what the reform in the human rights subject matter was a change in culture that allowed for the inclusion of the tools of other places where they had been working on them longer, and they had been approaching the issues of the education of the law or the application of the law. And I connect this with the judicial reform. I believe that the judicial reform attempts to consolidate the Supreme Court as a constitutional court. And what does this mean? It would be a court that is devoted to develop a doctrine on human rights as a prime objective. And this necessarily requires different institutional requirements. And I think it would be just indispensable that it's resolves on different cases. Today, the amount of cases are a lot, and it is not compared to other tribunal or other Supreme Court of the world. and it makes it difficult for them to build a constitutional doctrine when they are solving so many cases per year. On the one hand is the reduction of cases, and another piece that is important is the constitutional precedent. The Supreme Court is not only solving one case when it judges one case, it is also doing pedagogy at different levels. And what interests us in this conversation is the methodology used by the court in its resolutions that will allow the lower courts to approach certain subjects. And they depart from the example of those judgments, and that will give them idea how they will ground those methodologies in concrete cases. And if additionally it creates obligatory or mandatory criteria towards one judgment, I think that pedagogical work that will go down from the Supreme Court to the different judicial hierarchies, I think will allow for the better decision making. I think that the Supreme Court should be consolidated as a court that will be devoted to the Constitution and of the laws that of the rights that we all have. Thank you, Arturo. Thank you very much. Sadly, we have come to the end of this conference. Again, I would like to thank you for your participation in such a clear presentation and such a profound presentation of a topic that is important that we think about how to use this tool. We know that it's being used, and we need to see how this will adapt to the Mexican juridical reality. And thank you very much for the comments that we are receiving from the social networks. So they're committing you to continue to talk about these subjects. Thank you very much for your inviting me again. I want to thank all of you that are with us from the different social networks. We thank you very much. We are waiting for you at 11 o'clock for the second conference with Francisco Paul and Federico Espacio, talking about social rights and the contribution to the canon of proportionality. Thank you very much to all of the people who make this transmission possible. Behind this, a great effort of different sectors of the Supreme Court that are working together. Now, IT, the personnel of constitutional issues. Thank you very much to all of you, and we'll see you back in a half hour. Goodbye.